Good news, we will not receive notice High Court judgment for 2018-2019. Denial of ITC. Difference between GSTR2A and GSTR3B. Assessment order was passed on grounds that assessee has been said to have availed input tax credit higher than amount reflected in GSTR2A. In other words, input tax credit was denied on basis of difference of ITC between GSTR2A and GSTR3B. Accordingly, recovery notice was issued. It was submitted by assessee that as per various judgment issued by various judicial authorities, input tax credit could not be denied merely on difference between GSTR2A and GSTR3B. Held, matter was remitted back to file of assessing authority to examine evidence of assessee irrespective of form GSTR2A for assessee's claim of input tax credit. After examination of evidence placed by assessee, assessing authority was directed to pass fresh orders in accordance with law. Accordingly, petition was allowed. Section 16 of Central Goods and Services Tax Act 2017 Kerala State Goods and Services Tax Act 2017. Facts. The assessment order was passed on the grounds that the assessee has been said to have availed the input tax credit higher than the amount reflected in GSTR2A. In other words, the input tax credit was denied on the basis of difference of ITC between GSTR2A and GSTR3B. Accordingly, recovery notice was issued. It was submitted by the assessee that as per various judgment issued by the various judicial authorities, input tax credit cannot be denied merely on the difference between GSTR2A and GSTR3B. Held, the matter is remitted back to the file of the assessing authority to examine the evidence of the petitioner irrespective of the form, GSTR2A, for assessee's claim of the input tax credit. After examination of the evidence placed by the assessee, held, the matter is remitted back to the file of the assessing authority to examine the evidence of the petitioner irrespective of the form, GSTR2A, for assessee's claim of the input tax credit. After examination of the evidence placed by the assessee, the assessing authority was directed to pass fresh orders in accordance with the law. Accordingly, the petition was allowed. Rajesh Nambiar and Sindhu K. Nambiar, Adivis, for the petitioner, Rasmita Ramachandran for the respondent. The present writ petition has been filed, impugning X.P1 assessment order and X.P2 recovery notice dated 28/2022 and 24/7/2023 respectively. From the perusal of the assessment order impugned in the present writ petition, it appears that the only ground on which the petitioner has been said to have availed the input tax credit is the difference between GSTR2A and GSTR3B. This court, India Agency's view. The State Tax Officer, after taking note of the judgment of the Supreme Court in the case of the State of Karnataka vs. MS Ecom, Gill Coffee Trading Private Limited, 2023, 3, TMI 533 SC, as well as Calcutta High Court judgment in Suncraft Energy Private Limited. The Assistant Commissioner, State Tax, Ballygunge Charge, MAT number 1218-2023, dated 2/8/2023, has held that the input tax credit of the assessee under the GST regime cannot be denied merely on the difference of GSTR2A and 3B. Paragraph 8 of DR Agencies. Supra of this court would read as under: In view thereof, I find that the impugned Exhibit P1 assessment order, so far denial of the input tax credit to the petitioner, is not sustainable, and the matter is remanded back to the assessing officer to give opportunity to the petitioner for his claim for input tax credit.
If on examination of the evidence submitted by the petitioner, the assessing officer is satisfied that the claim is bona fide and genuine, the petitioner should be given input tax credit.
Merely on the ground that in form GSTR2A the said tax is not reflected should not be a sufficient ground to deny the assessee the claim of the input tax credit. The assessing authority is therefore directed to give an opportunity to the petitioner to give evidence in respect of his claim for input tax credit. The petitioner is directed to appear before the assessing authority within 15 days with all evidence in his possession to prove his claim for higher claim of input tax credit. After examination of the evidence placed by the petitioner, assessee, the assessing authority will pass a fresh order in accordance with law. In view thereof, the present writ petition is allowed. The matter is remitted back to the file of the assessing authority to examine the evidence of the petitioner irrespective of the Form GSTR-2A for petitioner's claim of the input tax credit. After examination of the evidence placed by the petitioner, assessee, the assessing authority shall pass fresh orders in accordance with the law. The petitioner is directed to appear before the assessing officer on 3/10/2023 at 11 a.m. with all the evidence in support of his claim for input tax credit. Thank you very much, and also do like, share and subscribe our channel for latest GST info.